Sally Wirtman versus Anthony Lee Little. This was filed as a termination of tenancy action. The parties lived in the same home, 6 US 12. Mr. Little is late, so Miss Wirtman gave me some information, and then he got here after that. She indicated she wasn't sure where he was. She still has property, motorcycles, a Jeep, clothing. He'd lived there for a year. Then he came in and said, well, I've had health problems. She messed with my mail. I didn't get my notices. He was forced out on July 7th. He's living in his truck. Anyway, I continued the matter until today, as the law requires, and see if we can get some solution here. Mr. Little, have you had an opportunity to get any of your property out of there?
Yes, sir, I did, Your Honor. I got my Jeep and some clothes and some other stuff, but I didn't get everything. I think I was denied getting my guns, and hunting season opened the 15th of September. I hunt, fish, and trap, and I don't know where my coin collection is, my mom's jewelry. Something else too, I'm trying to think.
Miss Wirtman, what's your position?
Well, he was there yesterday, but I was gone, and I thought he was supposed to call me and let me know beforehand when he's gonna arrive.
Well, does he still have property there?
Yes, he does. But I'm willing to let him get it, but he needs to let me know in advance. I need more than, 5 minutes.
Well,
Just a minute.
okay, sorry.
He's a lawful tenant. He has as much right to be there as you do. He doesn't have to call you and say, hey, I'm coming to get my stuff. He's not a squat, well, he may be, but anyway, he lived there long enough that he was a tenant. And if you prohibit him from coming in there, you're locking him out, which violates the lockout law. So it might make more sense if he let you know when you were there, but he doesn't have to. He has not been evicted. I haven't entered an order yet. You have 10 days from today to get your stuff out of there and move. Are you still living in your truck? Have you got a place to live?
I do. I live in my truck part of the time. So actually about the last 6 days, except last night.
All right, can you get the balance of your property out of there in 10 days?
Yes, sir, I think so. I hired a crew.
All right.
And I did get a storage area.
Very good.
I was trying to get a better shirt out there this morning, but they were laying pavement in front of my thing. It's brand new, so.
All right, Miss Wirtman.
Yes, I did ask him to move out October 25 of 24. And I told him that he could keep his stuff. Well, actually, I told him he could, by November the 24th is when I wanted him out, and that he could keep his stuff there until May the 1st, and then, in the garage, and then move that out. But that didn't happen. So, and then I did ask him after the first of the year to move again, but that didn't happen.
Well, it's very common. People don't move because they don't know where to move to. And in order to actually enforce it, you have to go through this process.
Well,
where I tell the people, you got to go by this date or the sheriff's got to throw your stuff out. And so he's got some. Does he still have guns and coin collection and that sort of stuff there?
there's still some stuff in the garage. There's some stuff in an enclosed trailer that I'm not going to leave unlocked because it's my trailer. He's got 4 bikes there. He's got a lawnmower. He also took the cover off of my motorcycle. He cut it off.
No, I didn't cut off. Actually,
All right,
that
well,
cover that was on there, that motorcycle never came with a cover. That was my motorcycle
all
cover.
right, well, if we're gonna
I
start
had
to
like-
argue about money damages for those sorts of things, you can file a small claims case. This is about possession of the premises and the property. So you have 10 days to get your stuff out of there. If it's not out of there, Ms. Wirtman, you can ask the sheriff to come put it out. 10 days from today is October 2nd.
Your Honor,
Yes?
when I went there to get my guns the other day on Friday, she said she didn't know where the guns were. And they were trying to get out of the house with my gun safe. She bought me a gun safe for my birthday, but they weren't strong enough to get it out of there.
All right, well, if,
So,
let's say you
She
can't.
says she don't know where the guns
All
are.
right, well then, if you want to sue her for money damage, you can file a lawsuit either in small claims or otherwise. So let's say you claim you've got $2,000 worth of guns that you couldn't recover. You can file an action against her in small claims court.
One of them is a registered firearm that was legally registered at the police station. And I have 2 clips and a whole bunch of ammo,
All right,
and
well,
that's missing also.
all
And I
right,
don't, you
then
know,
if you can't recover it, you can file, if it's over $7,000, you have to file it in regular court. I'm worried at this point about getting possession of her premises back. No money judgment is entered at this time until I have October 2nd to appeal this.
October 2nd or 7th.
2nd. It's 10 days from today, which is the 22nd of September. Let me recap. You got 10 days to get your stuff out of there. You need to have the property accessible to him, but she makes good sense. You need to do this when she's there because some of these outbuildings are locked. And if you got stuff in that outbuilding, then she can unlock it and it let you have access to
Your
it.
Honor,
Yeah.
it was raining Sunday morning. So I had to wait for the rain to stop, and I still had a load in the back of my truck,
All right,
and it was
well,
covered up.
you got 10
And
days.
and all that stuff was
And
sitting outside
If
when
you,
we went and picked it up.
all right, well, again, if there's issues regarding money damages, you can file small claims. This point, I want you to get as much of your property out of there as you can by October 2nd. And if you don't, then she can come here with $15 to the courthouse and ask for a writ of eviction. This relationship is ended. You need to go your way and she needs to go her way. And you need to get your stuff.
I got me a brand new big storage and it can hold everything.
All right, very good. Too
So
bad
I've
you
been
couldn't live
filling
in
it
it.
up.
All right, Mr. Little, you go with the court officer. We'll get you a copy of this order. Swartman, you wait here with me, and when he's done, we'll
Okay, thank
take
you, Your
out
Honor.
there, and you can get a copy. All right, good luck to both of you.
I made sure I was early today.
All right, very good. All right, thank you, Ms. Bauer.
Likewise, thank you, Judge. Have a good week. I'll see you later, I'm sure.
All right, I'll see you on Friday, I think.
Yep.
All right. Mr. Kloppenstein is here, and he's in the conference room, and Megan Bauer is here from Legal Aid. This is another in a series of mobile home cases where I believe we're talking lot only. I have a copy of the lease, but it's so small, they print 4 pages per page, and I need a magnifying glass to read it. But if I'm correct, Ms. DeCenzo, is this lot only?
Yes, lot only.
All right, and Ms. Bauer and Mr. Clappin said, we've been discussing this. I'm not sure they can even do this. They're doing it all over the state. The law is unclear whether you can file an action for lot only. Well, the
Judge.
proper- Yes,
I'm sorry to interrupt you, but I see Attorney Hull here. I couldn't find Ms. DeCenso in Relia Guide, so I was going to ask what her P number was.
So Kyle is who you've been working with probably, or associated with Kyle
all right,
Evans.
you're with the management company?
Yes, yes, as of today, throwing me
All
into
right,
it.
Miss Hull is here. She's from Swiss Stack Levine, and she's gonna be representing the company.
I'm sorry to interrupt you, Judge, but as soon as seeing Attorney Hall log in, I realized that plaintiff's counsel wasn't here at the beginning.
Thank you. I misunderstood Ms. DeCenzo's role here. Ms. Hull is an experienced landlord tenant attorney and has heard my discussion about whether they're even entitled to do a non-payment of rent in a lot-only circumstance. As I mentioned, some judges have made a ruling that you can't. I've been letting it go because it gives the defendant an opportunity to redeem the property rather than simply be subject to just cause termination. At any rate, Ms. Hull, good afternoon. What's the arrearage in this case?
Afternoon. I have that it's $2,441.90, and the costs are $170.05. The total is $2,611.95.
All right, what I've been experiencing in some of the other mobile home parks is it's hard to parse out what the number is. It includes utility fees, late fees, other sideways billing stuff. Is this all lot rent at $403 a month?
Looking at the ledger right now, Your Honor, yes, there's lot rent, there is water, I think. Like a mobile home tax, $3, admin fee, $5. These are pretty typical. And I see a loan, $95 a month. I don't know if they're in the process of purchasing.
He's still paying on the trailer.
Okay, so sometimes they'll have a,
It's like purchase credits to give them the option to own the home.
yes,
Sorry to step in.
no, that's okay. So yes, it's like they can use that as renting the home if they decide to move, or they can put that toward buying the home.
It might be in the lease, but since it's so microscopic, I can't read it. And I didn't want to go to all the trouble to blow it up. But I don't like it because I don't know how much is rent. I don't know how much is utilities. I don't know how much is ancillary costs. It looks like $2,441.90 of rent, but it isn't. It's other components to it. And I've been struggling with this with some other parks recently.
Well, the only thing I guess I could suggest, well, two things. I can send the ledger over or do sort of a breakdown. I know I'm new to this firm and I didn't used to do a lot of mobile home work prior, but when I came here, I was informed that there is a lot of confusion among different courts about mobile home site rent and stuff like that. I know that we do have a a brief or a memo on it that I could send over at
Your
some
firm,
point.
I've got a copy of your firm's brief.
Okay.
Well, Judge, I
Mr.
would,
Scorento, stop. Take that down. I didn't ask you to screen share anything and have you hijack my screen. So
Sorry
please
about that.
remove.
yeah, I was just going to object to that because of his personal information. Thank you, Judge.
All right. And Mr. Scorento, you're one of the owners of the park also?
That's correct.
Another thing I've been dealing with, fortunately, this park does not have, is water and septic issues. This park, I believe, is part of the Centerville wastewater treatment. And has city water and sewer, which is a benefit. Some of the rural parks we're struggling with. All right, so Meg Bauer would you go ahead and place your appearance on the record?
Yes, Your Honor. Meg Bauer, P84816, appearing on behalf of defendant Craig Kloppenstein, who has defenses to this matter.
All right, when was rent last paid here?
Well, Judge, that's actually part of the issue.
All right,
Mr.
well,
Klopp,
let me ask them. Ms. Hull, can you tell me when rent was last paid?
I can step in
Yeah,
if
go ahead. I
it
don't see
may
the payments on here.
May 30th.
For June.
All right.
Oh, yeah, that makes sense. I don't, mine starts in July. Yeah, and I don't see payments on there.
All right. Was it last paid in May 30th or last applied to May?
The last payment was made on May 30th.
All right. So no payment for June, July, August, or September, soon to be October.
That's
The payment in May was also for the month of June.
All right. We'll sort that out.
That is correct as well.
Yes.
Ms. Bauer, what are the defenses that you're addressing?
Thank you, Your Honor. Mr. Kloppenstein has made multiple attempts to pay his rent. Some of the things included in the total amount presented to you have not been mentioned yet. Namely, a lease violation fine that was imposed on Mr. Kloppenstein this spring that caused a fee to be added to his account. Mr. Kloppenstein disputed or has disputed that allegation that is an alleged breach of the rules. So that's the factual crux of the dispute here. He disputes violating the park rules. But consequently, he was prohibited from paying his rent because he would not pay that fine. In fact, I have record of evidence of him attempting to make payment on July 5th at 8:30 in the morning. He attempted to pay $561.88. On August 4th, he attempted to pay $1,135.88. And on September 4th, at approximately 11:40 a.m., he attempted to pay $1,737.03, which is the amount the defense purports or alleges to be the amount due and owing. Now, the problem is the plaintiff has very limited means of accepting rent. The only manner in which rent can be paid without incurring a mandatory you have to pay this fee for the privilege of paying your rent fee is through automatic deduction from his account, which would prohibit Mr. Kloppenstein from disputing the alleged fees. So he has attempted to pay through the Walmart online pay system that they require, which again comes with a fee. But if his payment is below the minimum required from the park, and I have pictures of the payment rejection, because it is not 100% of what they are demanding, they are rejecting the fee. Consequently, they are imposing over $100. I believe it's $175. Yes, they have imposed $175 in late fees on Mr. Kloppenstein for each of the months that we are not in dispute on him having money in. So June, July, August, and now September. So
All right, well, let me stop you. A couple of things. All right. Mr. Scorento, would you take your hat off? We are in a court proceeding. And people tend to disregard that we're in a Zoom hearing. You're saying he paid $175 for each month?
no, he tried each month to pay the balance that he had due. So in July, he
All right,
attempted
so
to
it's
pay over
$25
$500.
per month.
No, Judge, he's tried to pay $1,700 total. And each month he tried to pay his lot rent, his water, sewer, trash, etc. But each month it has grown because there's a new month due. And because they have rejected that payment, they have imposed a $175 late fee on his account each month.
All right, that's $175 a month late fee?
Yes, Your Honor.
Wow.
And in that micro print lease, it talks about maybe $100. It's first $75 and then $100 a few days later, I think.
All right.
There are
There's a
other
whole bunch
issues.
of issues here. I think the Landlord Tenant Relationship Act prohibits the landlord from charging a fee for the privilege of paying your rent. The old days of walking into the office and paying in cash are fading fast. The only way to do it is to have an automatic withdrawal from your account, which doesn't give you the chance to dispute anything. They take the money before you get a chance to raise the dispute. I can't read this lease because it's microscopic, but no one's going to let you charge $175 a month anywhere in the state. And that's a weird rental purchase. Some of it is the purchase price, some of it is late fee, some of it is the utility or other costs. So the first thing I'm going to need, Ms. Hull, is a breakdown of what it is that is alleged that he owes.
Okay. And I can send over the lease. The one that I have that's attached to my summons is very normal size and clear, so I don't know what
Yeah, would you
happened when I
please?
came over. Yeah, I can do that. I'll send one to Attorney Bauer also.
Your Honor, if I may say something,
If your lawyer will let you.
At the court's pleasure.
All right, Mr. Kloppenstein, your attorney doesn't object. So what did you want to say?
I just want to point out further in reference to the dates that Ms. Bauer provided you, that each month I had tried making the monthly payment. Those were timely made. That, but for them locking me out of the payout system because I didn't include all the fines and late fees, they rejected my monthly payment. So I was each month before the due date, and it was never late. It's actually due on the 1st according to the lease, and you gotta.
Okay, I got that from your lawyer's argument. But we're gonna have to spend some time on this. There's a whole bunch of issues. First of all, I want to figure out how they came to the amount they claim that you owe. And I want to get to whether you can pay your rent without automatic withdrawal, without paying a fee. And I know that's our trash hauler did that. You can't pay your garbage bill unless they give you automatic withdrawal of your account. So we changed trash haulers. All right, well, we have to continue this nonetheless for 1 month. One option, and I'm not going to exercise it at this point, is that I can set up an escrow account and have the money paid to me. Mr. Kloppenstein, don't squander that money. Keep it safe and sequestered, because you obviously owe something, because some of these months haven't been paid. I don't want you to get sideways because you make an insurance payment or you loan somebody some money or you take some of the money out of there. So hold on to it. This is not a termination of tenancy. So we just need to agree on how much the rent is, tell you an accurate figure and give you time to pay it. And that may solve this problem, but there's a lot of unanswered questions. So I'm going to continue this till next Monday, excuse me, at 2:30. Monday, 9/29/25 at 2:30. That'll give us 15 minutes, which probably isn't enough, but we'll take more time if we need it. In the meantime, Ms. Hull's going to send us a legible copy of the lease and a further breakdown on how much you owe and what each section is for. I mentioned this each week, Mr. Squarantino and Ms. DeCenzo. Mobile homes are changing. They're being bought by companies and they're trying to modernize things in a world that hasn't been very modern. But there are still rules. As I said, this is a non-payment of rent. In some counties, Livingston, for example, you can't file a case like this. That would leave Mr. Kloppenstein only with the option of moving. If they filed a just cause termination, he wouldn't have the right to redeem it. So I've been allowing these to happen. We're gonna either need some Court of Appeals opinion or a change in the court rule or a change in the statute, but nobody knows the answer to this question. At any rate, we'll address this further May 29th at 2:30. Ms. Hall and Ms. Bauer, you know how to get hold of each other. You've worked on a number of cases. So,
Yeah,
yes,
Oh,
somebody wanted to say something?
if I
Mr.
may,
Senzo?
yes, thank you, sir.
Yeah,
Just to, so that way when you get the ledger, you kind of understand that you'll see mobile home taxes, which this home is seller financed. Essentially, oh, go ahead.
No, Michigan's different, Chrissy.
Okay.
It does have mobile home tax.
Oh, yes, this is from
At the
this.
state.
From
okay,
the
well,
state.
we could
Yeah,
go over all
in the
this
state of Michigan.
after,
Yeah.
when this hearing's over.
No,
okay,
We
all
do,
right.
yeah, the home is seller financed, so it's not just lot rent that he owes, it's for the home. He is billed water based on his consumption, so.
Well, I'm not disputing that. I just couldn't tell from the way it was pled. I just got a lump sum that he owes this much. So how
Yeah.
much is the financing on the trailer? How much is lot rent? How much is water? Everybody agrees something's owed. We just need to figure it out.
Yes, sir.
All right, we'll address it next week at 2:30.
Okay, and just, I'm gonna, yeah, I have Evans on here, so I guess that's not the, if we can, I'll call you after.
Sure. And Your Honor, just to, so I have a good understanding of what we're getting into next week. Like you had stated, there's no questioning about money owed. We all can agree to that. You had talked about setting up an escrow account. Is that something that we can set up prior to the meeting? That way I know in confidence that if the defendant does indeed want to continue to live in the community, that there is commitment made on his end, just knowing the accommodations that we've made up to this point and trying to work tirelessly to accommodate.
You have an attorney. Your attorney speaks for you. And yes, I can set up a escrow account next week, but I'm not going to set it up right now because your pleadings are so bad. I can't sort them out. You sent me a lease I can't read. You gave me a lump sum spaghetti and threw it at the wall and hoped it would stick. And you've got fees in there that I'm not sure are legal to charge. And $175 late fee about knocked me out of my chair. So yes, I could set up a escrow account once I know a little more about it. So we'll address this next week and maybe be more on the more knowledge of what's going on.
Thank you, Judge. Mr. Kloppenstein, we'll be in touch after today.
all right, thank you, Ms. Bauer.
R. Casey LLC versus Carl Lockhart. This is a demand for non-payment of rent. The defendant was personally served. There does not appear to be anyone here on behalf of Carl Lockhart. Mr. Davidson, good afternoon.
Good afternoon, Your Honor, and happy Monday.
Oh, yes.
Thank you. It's been joyfully happy so far.
It's good to see Craig Kloppenstein.
Yeah, Meg's representing him. He's got some issues there in his tenancy. This is the apartments on River Street across from the Dairy Bar. I think there's 16 units in there. R. Casey Development LLC apparently owns it. Mr. Lockhart is a tenant there. Mr. Davidson, what's the arrearage here?
2,400 and then plus another 800 for this month is 3,200, please, Your Honor. And I was looking for, I thought I had Bruce's, oh, here it is. Fees of 39.23 for service from Bruce.
All right, 39.23. It's helpful of you to add these up for me. $95 filing fee, a $75 attorney fee.
Thank you, Your Honor. I'll add them for you real quick. I'll race you to the answer.
209.23. Total is 3,409.23. Mr. Casey, is the defendant still there?
No speaking. Yeah, this is Durrell Brown, Your Honor. He's the manager of the facility.
Okay.
And he says no.
Oh, he's not there?
He was incarcerated, Your Honor, and he let a bunch of people move into the apartment and they ransacked my apartment. And I changed the locks on them and told them that if Carl wanted back in when he got out of jail to come and see me. While that was taking place, they took everything of Carl's out of the apartment and including my stove and a few damages.
Where is he incarcerated?
He was in Centerville the last time I checked for home invasion.
Well, he's not there now.
I have no contact with him, Your Honor. I do not know where his location is at this time. There's significant damages at the apartment, and I would just like to get my apartment back and pursue him later for damages.
Every owner has had trouble keeping these apartments nice. There's multiple units in there. Anyway, he's not here. He's presently not in our custody. Mr. Davidson, you sent me a judgment and I'm gonna give a default on your behalf. $2,400 or so $3,200, $800 a month through September. 209.23 in cost. Total of 3,409.23. It's to Carl Lockhart and all occupants. 10 days from today is October 2nd. Are there still people in there?
No, Your Honor. Carl had the.
They just trashed it?
Yes, I have video.
All right, we can do that for a damage hearing.
But there was drug activity also, and they also was stealing the neighbors' properties.
I can't hear you very well. You're not close to the microphone, but you've got till October 2nd. Then you can secure writ of eviction, Mr. Davidson.
Thank you, Your Honor.
And if they vacated, you can simply take possession. But they've got 10 days to pay the rent, as this is a non-payment of rent case.
That's what we expected, Your Honor. Thank you.
All right, thank you. Good luck with this. It's going to be frustrating to sit on this property for 10 days, but
Your Honor,
we will. All right, thank you.
Happy Monday, Meg.
Thank you, Your Honor.
Thanks, you too, Matt. Tell Patty I said hi. Oh, he's gone.
Okay, that's that one. LVNV funding versus Charles Lammers. Mr. Lammers, did you have a seat right up here? Mr. Lammers is here at the court. The amount at issue is $501.26. The plaintiff has filed a motion for summary disposition, contending that the defendant has not stated a defense and there is no material issue of fact. The defendant filed a letter with the court, which isn't exactly an answer, but we accepted it as such. I don't have the knowledge to do the recount of MCR 2.301 and 302 correctly. I'm confused how to do this assignment. I don't have the money for a lawyer. I don't have anyone to help me with this matter. I'm on SSI, and this is not a great deal of money. This is the kind of case which could benefit from some sort of repayment agreement. Mr. Lammers, I don't fault you for this. Every week I do motions for summary disposition. And lay people do not understand the concept. And in civil cases, you don't get a court-appointed attorney. In fact, we wouldn't appoint an attorney over a $500 civil case, but in a civil case, you don't have an attorney. Legal aid sometimes will appear for people in landlord-tenant cases, rarely in collection cases. But in this case, you had a credit card. They've supplied hundreds of pages of your billing history. Credit card had a very high interest rate, but they all do, 23.33% or something. The motion for summary disposition, and we have another one of these, Mr. Lord, he's been through this before, but summary disposition is under Michigan Court Rule 2.116. In fact, I'm not even sure even lawyers understand it very well, but there are two sections that apply here, C9 and C10. They allege you haven't stated any defense. I don't have any money. I'm on Social Security disability. That's not a defense. The fact that you don't have any money is not a defense. The fact that you owe money. And there is no material issue of fact. You had this credit card and this is the balance. You are right. It's not an overwhelming amount. It could be paid off in installment payments or something. But they contend that you owe the money and I should issue an order to that effect. Ms. Servey, you wish to speak to that any further?
Judge, you pretty well covered all of plaintiff's bases. So we filed our motion here under 2.116 I1, C9, and C10. And in support of our motion, we've attached the card agreement, the account statements, which reflect the same address where defendant was personally served with the lawsuit and which they stated in their answer. Those statements reflect payments and purchases over the course of several years. We've attached the bill of sale documentation showing how the account was transferred from the original creditor, Comenity Bank, to the instant plaintiff. There's also what we call a redacted sale file, which references defendant's specific account through those transfers in the bills of sale. So at that, plaintiff would ask that you grant their motion, and also note that we've not received a written response from defendant to plaintiff's motion for summary disposition.
Mr. Lammers, that's quite a bit.
Yeah, I just didn't understand what I needed to do.
Well, don't feel bad. Many people are in that same boat. I'm inclined to grant their motion. Lay people are in over their head when they're in collection cases and they're not represented. The attorney that practice in this area are quite experienced and they do this all the time. And often lay people have more than one debt. They're struggling to pay a number of other bills. Mr. Lord is certainly in that category. He's been trying to keep all of his plates spinning and it's hard to do. At any rate, do you have the ability to make any sort of monthly payment on this?
Well, I can try and make a monthly payment, but I don't know how big I can go,
All right, well, I don't think you sent me an order.
I didn't.
No, just a
I didn't
minute.
know how
Miss
to.
Serby, I don't seem to have an order in there. I have the motion. And they
I
didn't break down
believe
costs.
it's the second last page, Judge, but we don't have the proposed judgment costs on there.
You saying I do have one?
Yes, there's an order that just states that plaintiff's motion for summary disposition is granted. And we have a proposed judgment that we can submit.
Maybe I didn't go far enough back. All right, well, let's talk about the costs because they're not in here. What are the costs?
Costs are $117.29. So that's five.
She froze. Must be really cold there.
Attorney fee of $20 with damages of $501.26 for a total judgment amount of $638.55.
Your screen froze while you were giving that rendition. So we had $117.29, $20 motion fee. What else?
And damages of $501.26. So total judgment amount of $638.55.
All right, Mr. Lammers,
Yeah.
can you pay $50 a month on that? Or is that more than you can afford?
Yeah, I think I can do the 50.
Could you accept that at $50 per month?
Yes, we could, Judge.
All right, I'd ask you to send me a judgment granting summary disposition in the amounts pled. Defendant to repay at $50 per month. What day do you get your check?
I get paid on the 1st.
All right, make it due by November 15th.
Okay.
And the 15th of each month. All right, Mr. Lammers, I found that you owe $501.26, $117.29, which is the service fee for the process server serving you and the filing fee to file the case. So the total is $638.55. At $50 a month, that would take 13 months to pay this off. And that is satisfactory to the plaintiff. Are you still at Ellerman Street?
Yes.
All right. My address, if you would email that to me, is 3B Civil at stjosephcountymi.gov. That address is on the notice. And I will sign it. And you agree to that amount and you agree to pay it at $50 per month.
Yeah, this is gonna be a struggle, but I think I can do it.
All right, well, if you can send 50, send 40. If you can't send 40, send 25.
Well, how much longer would 40 do?
40 would take about 2 years to do it.
Well, we probably should do 40 so I ain't hurting so bad.
All right, we'll do $40 per month. At that level, $10 a month can make a difference to.
And I'm gonna get a address or how to send this in.
Yes.
I don't have a pen with me.
All right, I'm gonna send you this order and it's got the telephone numbers on it. You should contact them and they'll give you instructions on how to make the payment each month.
Okay, they ain't gonna send anything in the mailbox or just, I just send it when I need to.
Yeah, you can set up a direct payment account or you can send a certified check or money order each month.
I do the money order.
All right. Are you retired now?
So me,
Yes.
no, I was put on disability years ago because I have mental issues with and bipolar problems.
All right, well, you're doing fine here today, and the fact that you don't understand this isn't anything to be ashamed of, because you're not a lawyer, and it's confusing to lay people.
Well, I'll be honest with you, I struggled through school learning, and I had special teachers in grade school, but high school I didn't have nobody, and I struggled all the way through.
Where'd you go to high school?
White Pigeon.
All right, well, we're all trying to make our way in the world as best we can. So I will send you a copy of this. I don't have an order because I couldn't find it, but even if I could find it, it isn't accurate. So she's gonna prepare one with these amounts, $40 per month, starting November 15th. And then when you get it, you should contact them for instructions on how to make the payment.
Okay.
All right, do you have any other questions?
No, I don't, Honor.
All right, thank you for coming in.
Do I have to go to the office?
Nope, you're good to go. I'll send it to you.
Okay.
If you have any questions, you contact the court.
All right, thank you.
All right, thank you, sir. You folks are here on what's called a termination of tenancy case. Your landlord wants you to move. As a defendant in a termination of tenancy case, you have the following legal rights. You have the right to obtain counsel for representation in this matter. If you cannot afford an attorney, a legal aid attorney may be available to help you. I think she may be joining us here shortly. But we do not have court-appointed counsel for civil matters. You have a right to a trial by a jury or by the court. If you do wish to have a jury trial, you must tell me at this first hearing and be prepared to pay the $50 jury demand fee unless the judge waives it for your inability to pay it. You have 5 days to file the demand in writing if we don't do it here. You have a right to have the case heard here in St. Joseph County where the property is located. You may be able to reach an agreement with the landlord by going through mediation. That still has never happened, but it might one day. If both parties are interested, we can help set that up. Or you may be able to reach an agreement with the landlord that means the case would get dismissed, in which case we could file what's called a conditional order of dismissal. This is a demand to terminate tenancy. The notice to quit was filed or served on you on July 7th. We're now into late September. Mr. Jeremy Gump is here on behalf of the plaintiffs. They still wish these defendants to move.
That's correct, Your Honor.
What's your position, Mr. Tullis and Ms. McDowell?
We found a place. It will be ready on the 1st of October for us to be able to move in. We've paid the down payment for it and got the key. It just needs work. The maintenance guy's working on the roof today because it leaks. But as soon as everything's done, we can move in on the 1st, and we just need at least until like the 5th, and we can be out and have the apartment cleaned and hand the key over.
All right, sounds like a good plan. Well, the law says, whether I like it or not, or whether anybody likes it or not, you're entitled to an adjournment of at least 7 days, which will take us till next Monday. Or I guess in the meantime, you guys could talk about a conditional order of dismissal if you agree to a move by a certain date. But I'm going to set this for 2:05 on Monday, September 29th. Does that work for you, Mr. Gump?
Yes, Your Honor.
The law would then give you an additional 10 days from that day, which would be October 9th, before they could ask for a writ of eviction. But if you would simply agree to move by a certain date and turn in the keys, they could agree to enter what's called a conditional order of dismissal. But for now, I'm just going to continue the matter for 7 days to next Monday, the 29th of October. And when you do move, you need to turn in your keys and give your forwarding address in writing within 4 days of your moving. Now, this hearing does not order any money damages. It simply orders possession. There could be a later hearing regarding who owes who how much money. This one just has to do with whether you're going to vacate. So the law requires I adjourn it 7 days, which is next Monday. And the law says you get 10 days from that day to move or you're subject to being evicted. Obviously, the sooner you move, the better for them. The other thing it's going to do, it's going to take you into the month of October and you're going to owe another month's rent. If you could vacate by the end of September, that's better for you and better for them. That would be next Tuesday. But once we have another month, you're going to be in for another month's worth of rent. Mr. Gump, anything to add?
No, Your Honor, I think the adjournment and then the normal 10 days gives them even more time than if we did a conditional order today, notwithstanding the rent that you just mentioned.
All right, well, you got a week and then you have 10 days from that to move or you're subject to being evicted, but we'll discuss it further next Monday. If you can be out by then, that would be great. It could save you a whole nother month's worth of rent. But if you can't be, they can't evict you until the 9th of October.
Okay.
All right, I'll see you next week. You did a good job of logging in on time. I can hear you and see you. You're welcome to come in live, but you're also welcome to come in by Zoom next week. All right,
It was Monday at what time?
2:05.
2:05. All right, thank you.
All right,
All right.
thank you.
Thank you, Mr. Gump. We'll see you again. I haven't seen you in a while. Must be everybody's been paying their rent. So
They
maybe
have been
that's
paying
good.
their rent. They have been paying their rent, Your Honor. A little rusty. Haven't seen you in a while. Good to see you.
Okay, I'm a little rusty too, but for just old age. All right, thank you.
All right, take care.